Hi friends from around the world, exhaustion of rights. So this is a bit complicated from the beginning, but it is not so complicated. The case at the end is quite easy to understand, and I think I will be short today of the 15 minutes to which I am used to make the presentations here. Exhaustion of rights, what does that mean? In principle, if somebody sells a good, a tangible good, for X amount of money, and the buyer has it in his own hand and it want to resell it with regard to mentioning the trademark what it is, or the owner what it is, or the author of what it is, the product. The author, the original author, has no bearing on it on this second sale. So if you remember, in the free video series I made mention to the NFTs, and there is a possibility of a smart contract where this smart contract in each resale of the product, of the NFT of the original author, it may be encrypted within that smart contract that for each resale the original author may get whatever amount it is in the contract. So that is becoming different, and the author has more options now with regard to these using the NFT. But this is more or less for artwork, right? So I'm talking about here ebooks. That is, well, let me come to exhaustion of rights in order to make it more clearer for you. Luis Vuitton, you know all the handbags of Luis Vuitton, right? The French handbag maker. And Luis Vuitton sells some handbag to an individual, and this individual wants to resell that handbag to a third party, and it makes reference to Luis Vuitton handbag. Well, that is exhaustion of rights. Luis Vuitton has sold the handbag in the first place in its own name, and it has received the reward for it, the price, the price which implies the goodwill of Luis Vuitton, and then the resale of that product is not anything business of Luis Vuitton. Its rights has exhausted with regard to that. So that is exhaustion of rights. Now, what do we have a case? What is the case here? It is a case of two Dutch entities, so to say. We have the Tom Book Club, which is a kind of book club of second hand, which has members on its own, and the book club allows the possibility for downloading the link through using the link provided by Tom Bookshop, whatever it was, to download and to read the book, right? Second hand, so to say. It has acquired the rights of that link, so legally, so to say, or the link, it has received the donor of that link from its members. So its members, they have acquired the right to download a link, and then this link has been passed on to the club. So that with the benefit that the donor, they have to pay less, right? So that was the system. It's a kind of peer-to-peer, which has been created by that company in the Netherlands. Now, the Society of Authors have sued that company for copyright infringement, and the owner of that club It says, well, you cannot because your rights have been exhausted. We have bought it legally in the first place, and then it is exhausted. So you cannot rely on your copyright anymore. So this was a deal dealt with in the Dutch courts and then went up the ladder and came to the European Court of Justice through a referring question from that Dutch court. And it is about the equivalent of Article 3 and 4 of the Copyright Directive here on the screen. Article 3 is about communication of the work to the public, and Article 4 is about the distribution of the work to the public. Communication and distribution. Article 3 and Article 4. So they are different, right? There must be something which is different among the one and the other. Now, what is clear is that Article 4, distribution of the work, leads to exhaustion, whereas Article 3 of the Copyright Directive does not have exhaustion as a consequence. So it was an important issue whether the law, the Dutch law on which the claimant, the Society of Authors' Rights or whatever, they relied on, is being subject to Article 3 or 4 or the equivalent of what has been transposed into Dutch law from that law. It has been transposed as it is said in the Copyright Directive. So it is not clear. It was not clear for the court what to apply, whether Article 3 or Article 4, and it has requested the European Court of Justice for clarity in that sense. Now, what does the Court of Justice said as to this? Well, they made a bit historical analysis of what was the Copyright Directive. Copyright Directive is already from 2001, so 20 years ago. 20 years ago, the technology was quite different, right? And it enters into the considerations of the directive. There are a lot of considerations which says a bit about the origin of why is it necessary to have that regulation or that copyright directive being done. So it enters a lot into that, and it came to the conclusion, well, from the outset, what is being viewed by the copyright directive, by the legislator, was that Article 4 is more the distribution of the work to the public is more about tangible products. It is not about any kind of means of communication. The rule by that was that the works which have been produced and which are distributed were tangible ones. Now, with regard to e-books, or with regard to books, so to say, it was distribution of books, and the exhaustion was justified in the sense that books over time deteriorate in their material consistence, in the physical appearance. They got worse and worse. You take an old book and you want to read an old book, probably you don't want. So it gets greasy, right? So the vision of the European Court of Justice was rather that the Article 4 referred to material, just before the dematerialization of all the goods and services since then. So there are a lot of dematerialization which took place with regard to photos, to to letters, emails, whatever it is, money, Bitcoin. So everything is dematerialized. And by 2001, when the Copyright Directive was, so to say, adopted, dematerialization did not exist so much. So that was with regard to the books and the e-books, which is a different communication now with regard of the electronic, provide an electronic link to look at something which is virtually existent but not tangible. So the e-book, so to say, that would fall under the communication of Article 3, meaning that if it falls under communication Article 3, it is up to the owner, to the author of the work, to participate in each communication and to authorize in the first place each communication of the work. So at the end, we have something which is in favor of the author's work. Well, the Copyright Directive in general was at its origin something to provide the authors a just and fair reward for their work, and the tendency of the case law of the Court of Justice is to provide just that. So often, well, we have seen in different judgments that the Court of Justice has a tendency to rule in favor of the copyright holders in order to get them to that reward. And this is more true with regard to the internet society where we are in, where everything can be shared immediately with everyone without any intervention of anything. So it goes quickly. Within a tweet can go viral within 1 hour or 3 hours or 5 hours or whatever, a day, you name it. But within a day, whether you get the reward for it, well, if you want to get a reward for the tweet, but that is not so, meaning that it goes very quick, right? Again, something which is interesting, and the interesting thing here is it was against another judgment from 2012 here on the screen, which involves Oracle and a computer program. In that case, it was more like distribution, but it was an early case, and here they twiggled around a bit. The European Court of Justice, well, the computer program is one thing and an e-book is another thing. So we want to compare one and the other. So it is a bit, although it recognized that they deviate a bit from that path initiated in 2012. So this is it. We will have more protection for the authors so that their work will pay out for them and the innovation of the works will be rewarded.